Welcome back. Before the break, we reflected on Justice Souter and the quiet courage it takes to step aside. Now we turn to a moment that reveals just how loud and divided the current Supreme Court really is, especially when it comes to religion, education, and parental rights. This week, the court delivered a 4-4 deadlock on a high stakes case out of Oklahoma, effectively blocking the creation of the first publicly funded religious charter school in the country. The case involved St. Isadora Catholic Virtual School, a proposed online charter school backed by Oklahoma's Catholic Diocese. The school's mission was simple but bold: bring Catholic education to rural communities through the state's charter school system. But not everyone agreed. The state's Republican Attorney General, Gentner Drummond, sued to stop it. And it is a twist only 2025 could deliver. The fight wasn't even between right and left, but among conservatives themselves. So here's what happened. The Oklahoma Supreme Court ruled that funding religious charter schools violates both the state and federal constitution because, again, we have separation of state and religion. St. Isadora and the charter school board appealed to the U.S. Supreme Court, arguing that charters are technically private organizations operating under public contracts, so excluding them on religious grounds is discrimination. But the Supreme Court split 4-4, with Justice Amy Coney Barrett recusing herself, likely due to ties with a former colleague who helped build the legal strategy for the school. And just like that, the Oklahoma decision stands. Not a national precedent. It only affects that in Oklahoma, but I assure you, with 11 other states passing the same type of testing the same type of laws, no majority opinion is a legal message. Let's be clear, this wasn't just about Oklahoma. This was a test case designed to challenge the limits of religious liberty within public education. If St. Isadora had been approved, it would have created a new legal category: religious charter schools, not private, not traditional public, something in between. Supporters say that the future school choice that meets families where they are, including faith-based needs. Critics argue it's a slippery slope, and it is. That it opens the door to taxpayer dollars funding everything from Catholicism to, oh, well, wait a minute, and Christianity, because Christians don't tend to think Catholicism is it. Even schools promoting radical Islamic views or Wiccan beliefs. Even A.G. Drummond, himself a conservative, warned that forcing the state to fund one faith would open the gates to fund all faiths, and he didn't mean it as a compliment. As a lawyer, I'll say this: the constitutional tension here is very real. On one hand, you have the First Amendment's free exercise clause, which says the state can't penalize a group just because they're religious. On the other hand, you've got the Establishment Clause, which says the state can't promote religion either. When you mix that with charter school laws, which are already a hybrid of public-private governance, you get murky legal waters. And at the center of it all, parents. Families who want faith-based options but can't afford private tuition. Families who feel locked out of the public system, and families who are simply asking, why can't my tax dollars follow my values? This case didn't end the debate. It just hit a pause. The ruling didn't create national precedent. It didn't resolve the constitutional question. And it won't be the last time this issue hits the court. As Nicole Garnett of Notre Dame's Religious Liberty Clinic put it, this question is still alive, and I believe the court will eventually rule in favor of religious charter schools. Whether that's true, I don't know, because it is an interesting conversation to be had, and one that has been had since the times of our founding fathers. But for now, the status quo stands. So what's the takeaway? The ruling wasn't a loss of religious freedom. It is a legal crossroads. It forces us to take hard but necessary questions about how we define public education, how we fund it, and whether school choice includes faith choice. Because in today's America, protecting religious liberty doesn't just mean keeping faith out of the classroom. It may mean finding room for it within. And that's a conversation worth having, especially nowadays when you see people not really having the compassion or morals or ethos. And speaking of constitutional discussions and potential showdowns, let's next dive into a developing story about presidential authority and congressional spending powers. The Government Accountability Office, or GAO, has just ruled that the Trump administration violated federal law by halting funding for a $5 billion electric vehicle charging station program. This program was originally authorized by Congress through the bipartisan infrastructure law passed in 2021. As someone with a legal background, I find the constitutional questions here fascinating. The GAO, which serves as Congress's non-partisan watchdog, determined this action constitutes an improper impoundment, essentially saying the administration, aka executive branch, aka President Trump, can't simply freeze funds that Congress has already approved. The White House, through Budget Director Russell Vought, is taking a bold stance here. They've rejected the GAO's findings, arguing the Transportation Department has legitimate authority to review and pause spending. Secretary Sean Duffy specifically cited inefficient guidance and failed performance in the EV program. This isn't just about electric vehicle chargers. It's about the fundamental separation of powers. The 1974 Impoundment Control Act, passed after Nixon-era overreach, specifically limits a president's ability to withhold congressionally approved funding. What's particularly noteworthy is that the GAO has opened over 36 similar investigations into the current administration's handling of federal dollars. We saw comparable findings during Trump's first term regarding Ukraine aid, finding that ultimately contributed to the impeachment proceedings. The administration maintains they should have broader authority to manage spending according to their priorities. Budget Director Vought has even questioned the constitutionality of existing impounding limits. Several states, including California, have now filed lawsuits challenging these funding freezes. This appears to be building toward a significant constitutional showdown over who truly controls the nation's purse strings. And as this story develops, we'll continue tracking whether the GAO pursues court action to enforce its findings and how Congress responds to what Democrats are calling executive overreach. And recall that the reason why this is going to be a constitutional issue as to who has the power or the right to determine the purse strings is it Congress, who Congress is responsible for passing the budget. Congress is responsible for allocating the dollars and the funds to each branch or administrative bureaucracy or what program. So the real question lies, does the president have the authority to retroactively, because that's what's happening here, retroactively decide, you know what, we're not going to give that money. We're done here. And though it really is about what is the separation of powers and such, it is also interesting to note that there is another event happening in regards to electric vehicles. So now you recall that California, among some other states, decided to put extreme restrictions on carbon and combustible or gasoline cars, trying to phase them out completely and try to make it where you can only purchase an electric vehicle. Well, with the lobbying efforts of the major car dealerships and car manufacturers, Detroit, Ford, Chevrolet, and such, they have now had Senate starting to pass major significant controls, taking the power away from the state, saying that only Congress is able to place emission controls, and thereby removing or preventing California and other states from making this huge impact of saying that eventually phasing out gasoline cars and that you can only be using electric vehicles. This, I'm sure, is going to be another lawsuit headed by California, most likely, and the other 11 blue states that have also initiated this. Because again, now it goes to, do the states in their separation, because remember that each state is sovereign to be able to make rules that impact its state. Does the state have the right to do such emissions, restrictive emissions, and eventual phasing out of gas, or is that truly something that falls only under the purview of Congress? So you see, we do have a lot of things that are happening, and some will say it's a bit of a burden, or is this really a headache? And like, some, I have friends that will say, what is up with Trump and him doing all this? But then again, it's like, what's up with certain states trying to push or force their agenda on the masses? It all comes down to constitutional separation of powers. Who has the right to make these decisions? Is it the executive branch that gets to determine that, hey, by the way, if we really have shortfalls and we have a deficit that is increasing to over 36 plus trillion dollars, we have the right to withhold funds so that we can save money until such time as we start running from a deficit budget but to a surplus budget? Or is it under Congress that says we allocated, we're in charge of the money, and you can only have a congressional amendment or bill passed terminating that funding? Then we have the other constitutional thing. Who has the power to determine emissions? Is it the state or the federal government? Where does the separate but equal cost go? We're going to take a quick break, and when we return, we'll discuss the House passing Trump's big, beautiful bill. Stay with us.